Single economic entity and corporate separatedness doctrine, a juxtaposition. Under companies' laws, a company is considered to be a separate legal entity distinct from its holding or parent company. However, the doctrine of piercing the corporate veil is an exception to the rule, and the court used this exception to penalize companies. Competition laws, on the other hand, validate the single economic entity doctrine, where entities within the same group may be considered as one for the purposes of claiming advantage from scrutiny of competition regulators. This paper aimed to provide a brief overview as to the interplay between the applicability of the SEE doctrine vis-a-vis the corporate separatedness doctrine, which hasn't been discussed by any regulator or authority or court in India. The law governing companies globally and in India recognizes a company to be a personality distinct from its shareholders. In the celebrated case of Solomon and KCO, Lord Hawkesbury has stated, a company must be treated like any other independent person with its rights and liabilities legally appropriate to itself, whatever what have been the ideas or scheme of those who brought it into existence. As a rule, a subsidiary remains a separate legal entity distinct from its holding or parent company. However, the doctrine of piercing the corporate veil is an exception to the rule that the company is a legal entity, separate from its shareholders. In the Escort case, the Indian Supreme Court had opined that the corporate veil may be lifted where the state itself contemplates lifting the veil, or fraud or improper conduct is intended to be prevented, or a taxing status or a beneficent status is sought to be evaded, or where associated companies are inextricably connected as to be in reality part of one concern. Thus, it may be safe to say that the court lifted the corporate veil when the device of incorporation has been used for illegal or improper purpose, such as to defraud creditors, to evade an existing obligation, to circumvent a statute, and etc. The single economic entity doctrine, on the other hand, goes beyond the company law concept of a company having a separate legal personality and recognizes that different juristic persons may, in certain cases, be acting and behaving as one. This paper aimed to provide a brief overview as to the interplay between the applicability of the SEE doctrine. Section 3 of the Competition Act 2002 provides for anti-competitive agreement and states, no enterprise or association of enterprises or person or association of person shall enter into any agreement in respect of production, supply, distribution, storage, acquisition, or control of goods or provision of services, which causes or is likely to cause an appreciable adverse effect on competition within India. Section 2 of the Act defines the term enterprise as a person or department of the government who or which is or has been engaged in any activity relating to the production, storage, supply, distribution, acquisition, or control of articles or goods, or the provision of services of any kind, or in investment, or in the business of acquiring, holding, underwriting, or dealing with shares, debentures, or other securities of any other body corporate, either directly or through one or more of its unit or division or subsidiaries, whether such unit or division or subsidiary is located at the same place where the enterprise is located, or at a different place or at different places, but doesn't include any activity of the government relatable to the sovereign function of the government, including all activities carried on by the department of the central government dealing with atomic energy, currency, defense, and space. The Act is unique in as much as it provides a definition of an enterprise. From the definition prescribed under Section 2, it entails that the enterprise is one which acts either directly or indirectly through its division or subsidiaries, thereby going beyond the company law concept of a company having a separate legal personality and recognizing that different juristic persons may, in certain cases, act and behave as one single entity. Thank you.